Hello, all, and welcome to the next episode of the Speed Mooting podcast. I am the host, John Dove. Tonight, we've got a very special guest on the podcast. He is a barrister and has also been a judge at multiple speed mooting competitions. So, our guest tonight is Mike Trevelyan. Welcome to the podcast.
Hi, thanks, John. Thank you very much. Thanks for having me.
Yeah, no, pleasure. Great to have you on. So, we'll start with a nice, easy, basic one. Would you like to sort of introduce who you are and what you do?
Yeah, sure. So I'm a barrister at Cornwall Street Barristers in Birmingham, although we have locations throughout the country, but Birmingham is our main base. I've been a barrister now for about 10 years or so. It's surprising where the time has gone. My main areas of practice nowadays, probably about 90% is falling under the banner of civil litigation. So mostly I do contract law, personal injury, bit of property work. And then the other 10% of my practice is asylum and immigration work, so a bit of human rights stuff at the tribunal.
Brilliant. Well, quite a varied practice there. So I'm sure you've got quite an interesting workload.
Yeah, absolutely. It's very variable, which is nice. I wasn't sure whether I wanted to keep much in the way of immigration work when I started to reassess my practice a few years ago, but it does really keep things interesting to have a couple of different irons in the fire.
Okay, well, we'll start with that then. We'll talk about sort of your day-to-day work. So immigration, it's the first time we've had a lawyer that does immigration work. Would you like to talk to us about the style of advocacy and which courts you appear in as an immigration lawyer?
Yeah, sure. So most of my immigration work is in the first tier immigration tribunal. Appeals from those decisions go to the upper tribunal and then on from there to the Court of Appeal and the Supreme Court. So most of the work I do is in the first tier tribunal, some is in the upper tribunal. And tribunal advocacy, as a general rule, tends to be a little bit more relaxed, a little bit less formal than court-based advocacy. And there are tribunals for lots of different types of disputes. So the immigration tribunal is one part of a much bigger tribunal process. And one of the benefits of the tribunal system is that the judges that sit in the particular types of tribunals, so the judges I'm in front of in the immigration tribunal, are specially trained immigration judges. So you get that benefit of knowing that you've got somebody deciding the case who actually knows what they're talking about. Whereas sometimes in the county court, you will find that judges are dealing with cases and they don't actually have expertise in that area in quite the way that we might like. So that's one of the major differences with the tribunal, a little bit more relaxed, a little bit less formal, but there's a great deal of expertise available if you need it in a particular case.
Oh, brilliant. That's, I suppose it's a relief to know that the judge actually knows what they're talking about.
Well, that's right. And it's one of those things because in the court, the court system, if you're appointed, say, to the county court, you might have a lot of experience in family law, say, but you might have never done a personal injury brief in your entire life. And then suddenly you're sitting as a judge on a fast track personal injury trial and you don't really know, you don't have that practical experience. So it happens more often than you might expect that you have a judge that you need to slightly guide through a particular issue.
Yeah. I'm asking this question now purely through interest. So you talked about how the advocacy was quite informal. How do you deal with evidence in chief in a tribunal?
So the evidence in chief is the same as in civil litigation in court. So it's witness statements filed and served in advance, and then you just confirm it. Cross-examination takes place in the same way, but due to the nature of the immigration tribunal, most cases also involve interpreters as well.
Right.
So things can sometimes become a little bit elongated, and you often have to try and accommodate for that sort of thing and the extra time. And also tailoring your questions as well, whether it's just confirming the statements in chief or particularly cross-examination. If you're cross-examining somebody who uses an interpreter, you have to be slightly more methodical and deliberate with your language than perhaps if you're cross-examining somebody directly in English.
Yeah, definitely. Well, an extra element to think about with the advocacy. So, yeah, interesting to hear about. So you mentioned that you've got a civil element to your practice as well. So I think you were talking about you did personal injury and contract claims as well, and a bit of property disputes. Do you want to give us a flavour of the of what your practice encompasses there?
Yeah, absolutely. So that is the majority of my work. Probably about 90% of my practice falls into the civil litigation definition. The personal injury work is mostly road traffic stuff. So people getting involved in various types of scrapes on the road and finding themselves injured. But I do sometimes do occupiers liability and that sort of thing, where somebody has gone out somewhere and injured themselves in some way and is trying to sue someone else for that. The contract stuff really varies. Some of my work is for household names like Travis Perkins or Toyota or big companies like that. Some of it is for much smaller businesses, and some of it is just for individuals who are suing or being sued pursuant to consumer goods contracts or something like that.
Oh, wow.
So that covers quite a broad range. And then the property work, I do a little bit of landlord and tenant and business leasehold stuff, and a tiny little bit of trust of land work where there's perhaps a dispute between co-owners of property or something like that. But that's very much a tiny adjunct into the rest of it.
I see. Okay. Nice to have a bit of good variety, though.
Well, absolutely. It is important, I think, to keep it varied and fresh. Otherwise, you end up in a situation where if you do too much of the same work, it can become a bit routine. Whereas one of the things I love most at the self-employed bar in particular is the amount of variety that you can give yourself through your workload.
Definitely, definitely. Okay, so we've talked about the present. Let's work backwards then. Would you like to talk to our listeners about your route to the bar?
So I took a very convoluted and circuitous route to the bar. And before anyone gets too excited about the way I'm going to describe it, I should say that at least part of the route that I took is now closed because I very much exploited a loophole that they then ended up closing. So I will try and talk you through it and highlight the bits that if you're listening today as a aspiring barrister, the bits that you can still do the way that I did and the bits you would have to do differently. So I started off quite traditionally. I did a law degree in LLB and I got a 2-1 in that. And then I moved on to do what in those days was called the bar vocational course. I think it's now called the bar practice course, having had a couple of different iterations over time. Finished the bar vocational course. And the next stage then is supposed to be pupillage in chambers. But although I like to think that I've made a passable career as a barrister, I was apparently not good enough to be a pupil barrister. So I spent some time working as a solicitor's agent, which is a great way of getting work experience if you're a partly qualified lawyer. You can go and work for a number of advocacy agencies who provide you with real cases. And that came about entirely through chance. I happened to see on Facebook that a friend of mine who'd done the bar course with me was suddenly talking about appearing in court. And I thought, hold on, you've not done a pupillage. How are you doing that? And it turned out he'd become a solicitor's agent. So I did the same thing. And then through that process, I happened again, quite by chance, to have a conversation with a colleague of mine who was a solicitor's agent who happened to mention that she was becoming a solicitor. And what she told me, and this unfortunately is the part of the route which is now closed, is that back when I did it, if you had been called to the bar, as I had been, then the Solicitors Regulation Authority treated you as a fully qualified lawyer, even though you weren't. So you only had to do what was known as the Qualified Lawyers Transfer Test, so basically a couple of exams, and then you became fully qualified as a solicitor. So you didn't have to do a training contract, didn't have to do the legal practice course. Once I'd become a solicitor, I continued working for the solicitors agency that I was working with, but then I did my higher rights of audience qualifications, and this is the thing that you can still do, as far as I'm aware. Do the higher rights of audience qualifications, and then once you've done them both, because there are qualifications in civil and crime, I think, or family and crime, or something like that, then you are entitled to be exempt from pupillage. So you can apply for a pupillage exemption to the Bar Council, and then rather than applying to chambers for pupillage, you can apply as a qualified barrister for tenancy. And so that's what I did. So having been unable to secure a pupillage, I spent a number of years finding other ways around it, and in the end didn't have to do one.
Very clever. Well, I mean, these are all the skills of a lawyer, aren't they? So
well, that's right. It's all about finding loopholes and exploiting them.
precisely.
Absolutely.
So you found your workaround for the rules. Well, good to hear that you made it to where you wanted to be anyway. And as you say, you've obviously made a good career of it if you've been doing it for this long.
Yeah, I like to think so. I mean, it seems to be going okay so far. So hopefully, there's many years still to go.
So on that note, then, what would you say is the part of the role that you enjoy the most?
I think being a barrister is one of those jobs that is unlike any other job. So, in a sense, it's difficult to pick out one thing that is the most enjoyable part because there are lots of it that's unique and they kind of interplay together. But I think fundamentally, the thing that I find most enjoyable about it is the problem solving element.
Hmm.
And that comes about in a number of different ways when you're dealing with a case as a barrister. So, the most obvious way, of course, is that normally when you're instructed, it's because there is a problem that somebody needs to solve, whether it's I'm owed money or my landlord's trying to kick me out or the Home Office wants to deport me. So, you get big problems in that sense. And the case normally is about solving a problem one way or another. And then you get smaller, slightly more intricate problems, which might be we failed to do something that we were ordered by the court to do. How do we get around that? What can we do to make it right? And then you can get even more minute problems that you don't necessarily have time to think about at length, which can be a witness has just given very damaging evidence, or somebody has just said
Yeah.
something that I was completely not expecting. What do I do with that when I'm in court in front of the judge? So I think that's the thing that's most enjoyable is that there's a lot of differentiation between different cases, a lot of different problems to solve. And so you get that, I think, intellectual satisfaction in a
Hmm.
number of different ways as a barrister.
Yeah, definitely. Completely agree there. And do you have any tips for aspiring barristers? So for those people that are looking to come to the bar, any tips in terms of um, sort of career choices on the way up there, or even tips for sort of applications and things like that?
Yeah, so in terms of the way to get to the bar, certainly, as hopefully my experience demonstrates, there are multiple routes. And actually, just a few days ago, we're recording this on Sunday, and on the Friday, I was at the Coventry University Law Fair talking to students there. And one of the things that was quite surprising for me there, talking to students in primarily their second and their third years, was that they tended to think and they tended to have been told that when you finish your degree and you're looking for your next step in the law, you either become a solicitor or you become a barrister. And it's a very fixed path.
Mm.
You pick one or you pick the other, and then that's what you've decided for the rest of your life. And what my experience hopefully demonstrates is that you can actually jump between the two a little bit if you need to. So I think in terms of advice for getting to the bar, I would say try and be flexible. Don't see a change of plan as necessarily derailing your ultimate goal. And if you, for example, decide for financial or other sort of job security reasons, for example, that you'd rather train as a solicitor rather than try and go to the self-employed bar straight away, that doesn't mean that you've given up on your dream of becoming a barrister. It just means that you might want to do something else for a few years and then do some other qualifications and come back. So I think that's the main tip I would give to people as to how to get to the bar is just acknowledge there are lots of different ways of doing it. And if you don't go law degree, bar course, pupillage, that doesn't mean that you won't get there in the end.
Yeah.
In terms of tips for applications, I'm actually right in the middle of marking some pupillage applications in Chambers. And a couple of years ago, I was the pupil supervisor for one of our pupils in Chambers. So I have a bit of experience of what we are looking for in Chambers. And I think obviously you need good academics and all of the rest of it and the kind of basic foundations. What I tend to say to people is a good CV, in addition to that, would have the three M's, which are mooting, marshalling, and mini pupillages. And of course, John, your work provides lots of mooting opportunities
Yes.
to people. And it's really, really important, I think, for people to have some mooting experience, and particularly if they can win competitions. That's a really good thing for them. Marshalling is studying by following a judge around. So you spend about a week or so at court, and you might follow one judge or a number of judges at court. That's a really useful thing because you see advocacy from the perspective of the judge. And mini pupilages are spending time in chambers, shadowing barristers, seeing court proceedings, that kind of thing. And I think that as a minimum, in terms of what sort of stuff you should have on your CV, if you have the 3 M's, then you're in quite a good position.
Yeah, definitely. It just shows that you've got that intention, doesn't it, to actually go to the bar, or at least two of the three, even, because by doing mooting, there's not much opportunity. You can't, as a law student, you can't just rock up a court and represent somebody. So you need that chance to do advocacy. So look for competitions, if it's mooting or plea mitigation competitions or whatever it is. And as you say, with the mini pupilages as well, you've got the chance to actually go into a chambers and really show that you follow barristers around. Are you actually interested in this career?
Well, that's right. I mean, I do think it's really useful to see different types of barristers work as well, because even somebody like myself who works as a barrister, I would have no interest in having different types of careers at the bar. There are numbers of different types of careers at the bar you can have. And I know colleagues of mine who absolutely love the work that they do, and I would have no interest in doing it. And I'm sure they feel the same about my areas of practice. So the reason I say that is just to make clear that it's worth seeing different areas, so family, crime, civil, immigration, courts martial, whatever it might be, because you might find that you want to be a barrister, but it doesn't necessarily mean that you want the same career as one barrister that you might shadow for a day or something like that.
Yeah, precisely. Very different careers, even down to not just the area of law, but what's actually involved. Some are very court based. As in crime, you'd probably be in court every single day. I imagine if you were a tax barrister, you'd probably spend a lot of time doing advisory work and drafting, and probably spend less time in court than maybe you would in crime. So there's even different elements to how practice plays out. And by going on those mini pupilages, you can say, I've seen this, this is what I prefer.
Yeah, exactly right. And another example of that is to do with the urgency of your work. So, in certain types of immigration work, which I have chosen not to do, you can end up with very urgent injunction work. So, you might think that you're settling down for dinner, and then suddenly you get a phone call saying, "Look, we've got to do this work by 7 o'clock this evening because the client's supposed to be on a plane home by 7:15." So, it's that sort of whether you want a career that's as dynamic as that, I suppose. Whereas for me, I prefer a slightly more sedate way of practicing. But so that's the thing. There are a number of different types of career at the bar. Absolutely.
Brilliant. Well, I mean, you mentioned the first then, which is mooting, and obviously this is the speed mooting podcast. So we run lots of competitions. We have our national speed mooting competition, and we also do advocacy competitions as well. And Mike, you've very generously given up your time on multiple occasions to judge at our competitions. You've obviously seen this type of advocacy at the coalface then. Are there any sort of common mistakes that you see from students that take part in these competitions that you think can very easily be sort of tweaked and improved?
Yeah, I think there are two things that tend to stand out as quite common mistakes. One is being too script bound. And I think that's increasingly common with remote moots because there's more of a temptation to have half the screen with your script on it and the other half of the screen with the camera on it, and you sort of flick between the two. That can be quite effective because, of course, if you've got a script, then you're going to hit all the points that you need to say. But where you become derailed is the moment a judge asks you a question and pulls you away from your script. Then when you try and go back to it, you'll find that you've lost your place and you've lost your flow. And so a lot of people use scripts as a bit of a comfort blanket, but it's really, really important to try and get away from that as soon as you can. Even if it's a question of going from a full verbatim script of what you want to say, initially just to paragraphs, maybe that you feel you need to get absolutely right. And then from there, sentences, and then from there, individual words or phrases that are going to trigger what you need to say in the course of the moot. It doesn't have to be a binary. I either script everything or I just turn up and wing it as I go. And there's plenty of ways of working from one to the other. But that's quite a common problem, that people are just too script bound, and it does them a disservice. Because actually what you'll often find, and I ask a lot of questions as a moot judge, because it's the best way of testing advocates. And often what I find is that when you ask a question, you get a really good answer back. and there's no way it could have been scripted.
Yeah.
So the advocates could actually do it without a script, but they don't have the confidence. So that's the first thing. The second thing that I find is quite a common mistake, which can really derail your mooting very, very badly, is if you try and go beyond the information that you've been given in your brief and in your question. So sometimes I will find advocates that will try and bring in additional facts that aren't part of the fact pattern that they've been given. They might even try and bring in additional evidence to a moot by relying on documents that aren't part of the moot problem and things like that. And it does enable them to make what is on some view a clever or intricate submission. But quite often you find that it just derails the moot completely, because you're actually spending a very limited time talking about something that's outside of the scope of the moot. And I think one of the things to bear in mind if you are a mooter or an aspiring mooter is to remember that it is still an artificial process. So you are given tram lines within which to work.
Yeah.
So although it is sometimes possible to bring other stuff in, if you haven't been given it, then it's just to keep the focus on what you should be doing.
Yeah. Keep it simple. I mean, that's exactly what we do with our mooting competitions. There's different ones out there, but with ours, there's no drafting and no research involved. So everything's supplied to the mooters, all the legislation, all the case law, the skeleton arguments are even pre-drafted. So there's nothing else that you can bring in. It's all there. So yeah, as you say, by trying to add anything else in, it's just sort of convoluting the issues. Keep it simple and show that you can use the material that's before you to present the most persuasive argument. It's interesting that you mentioned judicial intervention and that you ask lots of questions to sort of test the mooter. One of the pieces of advice that I give quite regularly at the Advocacy Club is to really focus on judicial intervention. You know, think about where the weaknesses in your case lie, where are the strengths in your opponent's case, and you can bet your bottom dollar that is going to be the focus of the questions. So think about those beforehand, and then you know roughly which questions. You won't know the specific form of the question, but you'll get a good idea of the question, and you're ready that when the question comes, you can deliver an intelligent answer.
Yeah, absolutely. Absolutely. I mean, it's a little bit like a job interview in the sense that you can look at your own CV and you can kind of see where weaknesses might be or where questions might come. And you might then have in your mind a sort of outline of a possible answer to a number of different questions that might arise from a particular point. And then when you are asked the specific question, you can just add the specific detail. And I think mooting is quite similar to that in the sense that you can have an idea as to where some of the questions might come. Absolutely.
Perfect. Well, you've given some great advice for our listeners there, Mike. We're just about to come on to the final quickfire round now. So a few questions, non-legally based. So quickfire round of questions.
I'm very excited about this. I should say I got sent an agenda beforehand, John, as you know, but dear listener, I got sent an agenda and it did say quickfire questions at the bottom. And I thought I'm very excited about these. So here we go. The pressure is on now, John.
Well, given how excited you are, the most important question, I'm going to save that one for the last then.
Excellent. Excellent.
Okay, so first one. You're probably going to be a bit dissatisfied with the first, favorite holiday destination?
America. Yes.
Okay. Anywhere specific?
Well, I went to America and I went to New York and Washington and that kind of thing. Had a bit of a travel around, and it was tremendous, really, really good. But what I would like to do, which I haven't yet done, is to go to the southern states of America and kind of spend a bit of time down there. I think that would be really interesting.
Yeah.
I get the impression it's a very much more chilled way of life, a little bit slower paced than in the big cities, I think.
Yeah, I went to Texas a couple of years ago because normally in the past I've been to each of the coasts. So I've done a little bit of the East Coast, a little bit of the West Coast. And the first time I've been anywhere sort of central was Texas. One of the best holidays I've ever had.
Oh, really? Really?
Yeah, really recommend it.
Oh, brilliant. Yeah, I might look into Texas then.
I got my pickup truck, the 10-gallon hat, the lot.
Excellent. Excellent. I look forward to seeing a picture of that as well. I want to see you in your
I will show you. Right, okay. Favorite food?
Now, I actually, about an hour ago, I treated myself to a large curry and it was absolutely delicious. So the temptation by sort of recency bias is to say curry, but actually my favorite food is fish and chips. Classic.
Perfect. Like what I like to hear. Favorite movie?
I've recently actually been getting into films and I watched Rocky and Rocky 2 for the first time recently, and they were great films, really, really good. So I would recommend. I'm going to slightly cop out and say the Rocky series if I can.
That is funny you should say that. Literally this past week, we've been watching them from one all the way through to the Creed film. So we finished Creed 2 last night.
Oh, brilliant. Brilliant.
Yeah. What that was pretty weird that you've just I'd seen a couple previously. So I'd seen 4, 5, and 6, I think.
Right.
4 was my favorite, I would say. But yeah, the originals I'd never seen, 1, 2, and 3. So we decided to watch all through.
Oh, brilliant. And they're great, aren't they? I think they're fantastic. I think what a lot of people, I suppose, nowadays kind of don't necessarily realize with them is, particularly with 1 and 2, a lot of the stuff that's become a kind of trope of films started with Rocky. So stuff like the montage scenes when he's training and all that kind of stuff, which, looking at it now, you see parodied a lot and you kind of think it's a bit cheesy. And it is. But when you think that actually when Rocky was done, that was something new, that was the original creator of that kind of scene. So I think when you see it in that context, it's a bit more of an inventive film than it might seem to a modern audience. Absolutely.
Definitely. Yeah. Good films. Okay. All right. Well, this is the big one.
Okay. I'm excited.
So I'd be interested to get your opinion on this. Are you ready?
I am. I think so.
Crisps on a sandwich.
No, absolutely not. I saw this the other day. A friend of mine started putting crisps in a sandwich, and it's genuinely the only time I've ever seen it in my life. And wow. I was horrified by this, absolutely horrified. So no, what you want to do is you want to have your sandwich, you want to have your crisps. You can have them at the same time, but never the twain shall meet.
Interesting. You are now the second guest on this podcast to vote no on crisps on a sandwich. It would
excellent.
We'd had a really good run. We were undefeated for a long time, and then that's on the bounce way. We've had a no. So
there we are. See, and you say we, which gives away your own pro crisp bias.
Very much pro crisp. Yeah. So I say flame grilled steak McCoys on a cheese sandwich.
Oh, now I have to say, flame grilled steak McCoys are my favorite crisp. But I am afraid I'm going to die on this hill and say they must not go in a sandwich, no matter how much I like them.
Interesting. Well, I think we'll leave it there. Mike, you've been a fantastic guest. Thank you very much for coming on the podcast.
Not at all. Thank you for having me, John.